Good afternoon. Is everybody ready for me to start? Okay. My name is Kevin Fowler. I'm an attorney with Legal Aid of the Legal Aid Society of Middle Tennessee and the Cumberlands. I've been a practicing attorney since 1990. I'm born and raised in Clarksville, and I went to Middle Tennessee State for undergrad and University of North Carolina for law school, and I've been with Legal Aid of Middle Tennessee since 1993. And I believe what they've asked me to talk about today is general sessions practice, generally what we do. And I think my impression is that you probably want kind of a practical, nuts and bolts kind of understanding of what you would face if somebody asked you to volunteer and work on a case. The first thing I can say is that I'm not real comfortable with talking directly into a microphone, so I hope this goes well. And if you do any general sessions practice, rarely are you talking directly into a microphone. But the two areas I'm going to talk about are landlord-tenant and debt collection practices. And is that sort of what y'all understood what I would talk about? Yes. Okay, great. Well, the first thing is, of course, and I did provide materials, so I hope a lot of y'all have those. And I've done a lot of practice in landlord-tenant and debt collection. And that's an ongoing thing, and most of what I do is very practical and straightforward. The first thing about general sessions practice, of course, is what do you expect? What's it like? I would assume quite a few of y'all already are practicing in that area. Could you raise your hands if you've handled a case in general sessions? Okay. Well, a lot of you would probably be better up here than me then, so I don't know, but hopefully I can explain some things. I mean, the first thing about general sessions to understand, and I'm not sure where everybody's from, but every court is different, every county is different, every judge is different, and that's true even of courts of record, but I think general sessions in particular can really vary, especially when it's county to county. I'm in the Clarksville office, and we actually cover 7 counties, and in one county, in Montgomery County, of course, there's actually 3 different judges, and every one of them runs their court slightly different, and you can experience different things. It's going to be generally, and I hope I'm not being too simplistic, but generally it's like any other court. You have a docket call, and they'll call out the warrants, and then you, of course, are prepared to answer. To give you an example of how different that can be, though, if you go to Clarksville, what they actually do is allow the attorneys who are representing the plaintiffs to actually gather their warrants, and they actually call out the cases for the individuals that have shown up for their cases. So it processes much different. In some counties or in some times you'll go and they'll actually have a trial the day that the docket call is done. Most courts will allow you one continuance, and if you're going to set it for trial, say in Montgomery County, it can be set well off. So those are just some of the really basic practical things about whenever you're going into general sessions court, what you want to be prepared for. One thing you should do, of course, is always arrive a little early, unlike I did today, so that you're not quite as harried when you go to speak to the court. But what you would do is arrive a little early. You can understand what's going to happen in there. I guess most of you are from Davidson County, if not all of you. No? Okay, so there's a wide-ranging group of people. So it is correct for you to expect something very different in every general sessions court. The other 2 little practical things always to keep in mind is rules of civil procedure don't really apply. I think most courts go by them because it makes it easier, but I think it's a very common misconception to think that rules of procedure automatically apply to general sessions court. And also, although a lot of the courts I don't think adopt them, as everybody tells you, always get the local rules of that particular court so you're prepared from that. So I guess if I was going to address what I think you folks are here for, you get a call, they want you to do a pro bono landlord-tenant case. What can I expect? What are the kind of concerns that may come up? Has anyone in here ever handled a case on behalf of a tenant in a landlord-tenant case? Okay, so there's a few of those. And of course the first question is what law applies? In Tennessee we have adopted, and I'll just start with the landlord-tenant cases. In Tennessee, they have adopted the Uniform Residential Landlord-Tenant Act, but of course it only applies to certain counties. It does apply to Montgomery County, but all the other 6 counties we have operate under the common law. And so what are some of the major issues that if you're representing someone of our cases that we tend to have in tenant cases. What are the first things? The typical scenario is they've received a detainer warrant. They typically haven't gotten any kind of notice of termination, and they're wondering what they have to do. Do they have to get out? What do they need to do? And that's usually one of the biggest issues that arises in a landlord-tenant case. And that involves the issue of notice, what kind of notice is required, and whether the lack of a notice may be a good defense to a detainer warrant. Frequently, like I said, what will happen is the client will either post it to their door or something like that. They'll get the detainer warrant, and there will not have been a notice, a 30-day notice or a 14-day notice as is required now. So when I gave a talk to Montgomery County, I was trying to tell them ways that they could help their landlords in order to avoid losing cases like that, because that's the most common defense. Now, the other practical problem with that is, and I don't know if you've experienced, General Sessions judges don't necessarily want to follow closely what the law may require. Sometimes there's pushback because frequently the client that's going to appear to you is going to be a non-paying client. They haven't paid their rent, so why am I letting them stay in that apartment, or why am I letting them stay in that house? So that's usually the first and most difficult thing you have to face about that. Now, legally, you may have some very good defenses, and one of the most common ones, certainly in UROLTA counties, as I'll call it, or Landlord-Tenant Act counties, is whether they have waived the right for notice due to non-payment of rent. And in the materials I've provided, one of the first things I talk about is the fact that in your lease agreement, of course, you can indicate that you're going to waive your right to notice for non-payment of rent, and they can proceed directly to a detainer warrant. So they don't have to wait in cases where it's just non-payment of rent, but you have to have that clause in there. So, and you're welcome to ask questions as you go along. I don't know how they're doing it or if you prefer to wait to the end of it, but it's fine to ask questions to me if you want to. Plus, it'll make me know whether you are following what I'm talking about or if I'm just rambling.
I haven't seen those handouts that you mentioned.
No, the handouts were actually provided in the email that you received, or either I think that they're available on the website is what they had. I'm sorry that you don't have those. They asked us to provide those beforehand, so I did provide them, and so you can actually access them at the website. And so the first section, and then I'll just go over that so you kind of know, the first section that I brought up was the Residential Landlord-Tenant Act. So I have several of those statutory sections that I sort of just did a very brief reference to, and so those are in the materials. I can refer to the section at 6628-201, and the most important thing that comes out of that, like I said, is that you can waive the right to notice for non-payment of rent. There are certain requirements of how it's got to be displayed in the lease. That's another common mistake that a landlord would do. You've got to have a certain type of font. And I think that's commonly something they don't do. Now, whether you can convince a General Sessions judge that just because of that or the font's incorrect or it's not in all cap letters or whatever else is required, and again, it is in the statute, I'm not sure you can do that, but that is something you can use as a defense. As far as the notice is concerned, too, with regard to public housing, if you were to handle one of those cases in the Volunteer Lawyer Project, public housing units tend to want to work with you anyway, I think. They want to resolve it, and most of the time, unless it's a drug-related offense or some sort of criminal law offense, we've had a lot of luck and a lot of success of negotiating some sort of resolution short of eviction, especially because those folks typically don't have options. That would apply also oftentimes with Section 8 housing, too. But the most important and the most common problem that you have in landlord-tenant acts, or the one that you may be able to use as a defense, is lack of proper notice. But again, don't forget that if they've waived it in the lease agreement, then they don't have to, and they can proceed directly with a detainer warrant. And frankly, if there are folks out there that represent landlords, it's one of the most common things to recommend to them to make their situation a lot simpler is just include that provision, and you don't have to worry about the notice provision and how long it takes before you can actually proceed with the detainer warrant. The next thing is, of course, security deposits. 6628-301. They have very specific requirements with regard to the security deposit and what you have to do with it. You have to keep it in a separate account. You have to provide the location of the a security deposit, and you can't retain it under our law, under that section, if you do not provide it in a separate account. And if the people do default on their lease agreement and they've not paid rent, you can actually retain part of that deposit and apply it to the rent. But that is often a big problem and a big dispute in our cases as well. In addition to they hadn't paid the rent, most of the time, of course, you're going to utilize that against what damages the tenant may owe anyway. But what we commonly have is they're not going to provide the right information on the security deposit. The law actually requires also that they do a walkthrough, that they provide a list of what they're going to apply as damages to the security deposit, and that's frequently not followed as well. And strictly under the statute, under 6628-301, you actually aren't allowed to then keep any portion of that security deposit. At best, what that may do, of course, is diminish the amount of damages your client owes for non-payment of rent. Because, again, the vast majority of cases are where you've had a situation where the tenant has stopped paying rent, and that's why they're trying to evict them. In addition to that, if there's the next section we have a lot of problems with is that they want to impose some sort of rule, or they're trying to evict them because they have violated some rule. The most important part of that is that the rule has to be something that has been provided to the tenant prior to that, and certainly amendments have to be provided to the tenant as well. Those kind of things tend to deal with, or the ones that I've experienced tend to deal with noise, making too much noise, things like that, unwanted guests, and frequently you can get around those kind of problems or defeat those in general sessions, or I've had somewhat luck doing that. Another common problem, and I hope this is addressing some of the things y'all were interested in hearing about, but another problem is we get calls about the landlords coming in when I don't want him to. And there's a very specific section, 6628-403, and of course this is all under the Uniform Residential Landlord-Tenant Act, talks about when a landlord can access the property, when he can come in. He, of course, can have emergency access. Otherwise, it would be pursuant to a court order or some sort of notice to the person if you've been absent for 7 days or more. So the important thing about your ROLTA, or the application, if you notice, is that it's wanting to have clearly some sort of uniformity with regard to how landlords can act towards tenants. And this is one of the most common complaints we get from clients as well, that there's unwanted contact and unwanted visits in their property. And you can, again, refer to 6628-403 for that purpose. We also have some cases involving abandonment and claiming that the tenant was gone for enough time that they are able to re-enter and try to sell their property or do other things. The provision for that is 6628-405. And again, I'll say if you don't have the materials, I have all these in the materials, or I did reduce them somewhat. And then that has to be shown that the person was gone for at least 10 days. And that's always a big argument. Maybe their utilities were shut off. That's always something that they try to claim as indication that they've been gone or that they've abandoned the property. That'll often crop up in the cases we handle in general sessions. And then the big problem is that they then can dispose of their property after 30 days and apply that to any damages they may have to the property itself or in the matter of rent. So abandonment is also something that comes up often in our landlord-tenant cases. The other area that's probably most common is a reduction in what they call essential services. Under 6628-502, the landlord is prohibited from reducing essential services, which is typically gas, heat, and electricity is what they identify. I think there's always been a question in a lot of our cases about air conditioner. The air conditioner goes out. Is that an essential service? Do they have to have it repaired within a certain time, or can I then turn around and reduce my rent and repair it? And that's what that section, 6628-502, gives you a right to do, is that if they're on notice that there's a repair that needs to be done and they've not done it within a reasonable amount of time, one of the things the tenant has the right to do is to reduce their rent by the amount that they can repair whatever item it is. The big problem comes in, again, in determining what may be an essential service. Obviously, electricity, gas, things like that are pretty clear. But I think it may be questionable as to whether air conditioning is. And then the other concern I always have if I ever try to advise a client about doing that, of course, is what is a reasonable amount of time. And if you have 3 judges, I would bet you'd have 3 different determinations as to what is a reasonable time for that to be fixed. But that section does give you the right that if there's been deliberate or negligent diminution of the essential service to actually get the repair done and reduce your rent by the amount that it takes to repair it. Now, if there is a situation where there's either been a diminution of services or there's been some attempt to lock out or unlawful ouster, which is what that would be called, under 6628-504, there's very specific things that a tenant is allowed to do. They, of course, can recover possession, they can terminate the lease, and they can also ask for actual and punitive damages and attorney's fees for any kind of diminution in service or unlawful ouster. What that typically happens with ours is you have an illegal lockout or you have them cutting off electricity. Or as in some cases, I had a few cases where one of the trailer park owners was actually taking doors off of their houses when they wouldn't pay their rent or off the trailer and forcing them to have to take some sort of measure to either leave or something like that. The Landlord-Tenant Act, and again this only applies to certain counties, gives you very specific rights to actual punitive damages and, most importantly for maybe your purposes, attorney's fees in order to allow them to get back into their property or to certainly get things turned on. What we do in our practice is typically we'll send a letter first advising them that the law does not allow them to diminish their services while they're still in possession, even if they hadn't paid the rent. And that's a constant struggle in our kind of cases. Most landlords have frankly responded to that and have renewed the service, but that's usually related to electricity, obviously. But they do have the right to then sue them for punitive damages and attorney's fees. Again, you run into the practical problem that most of the time they're doing that because your client or the tenant has not paid rent. And so you're in a position where, if anything, you're trying to diminish the amounts your client may owe. And whether you're actually going to get any kind of substantial damages or anything like that is another question. But certainly it does allow you to get those services restored and that sort of thing. The important thing, too, in my materials, I added a section on the notice requirements. It used to be that if you were going to terminate a lease, it was a 30-day notice for non-payment of rent. And, of course, now it's 14 days notice. And I did provide that statute. It's under 6628-505, which, of course, is a huge and important component. That can get confusing, too, since most everybody obviously has a 30-day lease agreement. But the important thing, too, for your clients is that you're allowed to what we call cure that. So the scenario is the landlord sends them a notice and says that I'm going to terminate your lease agreement within 14 days under the law, and again it's 6628-505, you have the ability to remedy that in 14 days, and then the landlord is not allowed to use whatever that basis was that they listed in the original notice to actually terminate the lease. So that includes, of course, non-payment of rent. Now, the Landlord-Tenant Act requires that you have a 5-day grace period anyway. So you get 5 days into it, and then they send a notice saying we want to terminate your lease. Then your client could actually pay the rent within the 14 days. And that would allow them, of course, to not be the lease be terminated and subject to a detainer warrant at that time. I think it's common for them to accept the rent and then turn around and still try to do the detainer warrant. So one of the great things you can do if you're in a situation like that and representing a tenant is that you can help them get the money or help them get in a situation of paying that. And if the detainer warrant does come later, you've got a very strong defense as to them being allowed to proceed with a detainer warrant based on non-payment of rent in that situation. I'm going to talk to you about accepting rent without reservation in a minute, which is an important part of that. So not to confuse it, and I don't think it is that confusing, but just to be sure that you understand what happens. You get the termination notice. It's a 14-day notice, and the bottom line is your client has 14 days under the statute to actually remedy the non-rental payment. Now, I've also done it, and it doesn't really list it in the statute. The statute only lists repair to damages, cost of repairs, things like that. So you have a damaged storm door, or you have something that hadn't been fixed and it was caused by the tenant. Tenant gets that fixed within the 14-day period, and then technically under the law, they can't proceed with the detainer warrant under that basis. The one important provision, though, is if you ever cure a situation like that, and the same thing, substantially the same thing, happens within 6 months, then the landlord has a right to just give 7 days notice, and you can't cure it at that point. So it's one of these situations where you get one shot at it, at trying to cure whatever problem that they're claiming they're going to terminate the lease for in those circumstances. Now, I'm sorry.
Yeah, the 14 days to remedy the non-payment of rent, that's triggered on receipt of the notice from the landlord?
That's correct. That's my understanding of how it goes. So as soon as you get that, you have 14 days to cure whatever it is. Now, the problem is, and I'm going to talk about it again in a minute, and if I get out of order, I'll get more confusing than I already am. There's a case, Morrison v. Smith, that I also have in my materials that I'm going to get to, that talks about how you cannot file the detainer warrant until the period of time has passed that is the termination period. So if you have 14 days, a lot of times landlords, and again I'll go into it more clearly in a minute, will file a detainer warrant prior to the full termination period going. But you definitely have 14 days to cure it within that, and it is from receipt of that. That can be a dispute too. They leave stuff on doors, they slip it through their, so you can actually get kind of silly as to how much you could argue over time periods and which one applies. But certainly it's within 14 days that you can cure it.
The 14-day cure for non-payment of rent would not apply where there's a written waiver in the lease, though, correct?
Exactly.
And in that case, as long as the landlord waits 5 days, then on the 6th day, the landlord can go ahead and go straight to court with a detainer warrant and not give notice.
Exactly.
Okay.
Exactly. And that's an important thing. And again, what I mentioned, and this is for people who may be representing landlords as well, that is a big thing that landlords do not use consistently that could save them a lot of headache, to be honest, because almost all of our cases are non-payment of rent. These rarely are cases that are talking about behavior or something of that nature. I'd say anywhere around at least 80%, if not 90% of our cases involve a failure to pay rent or partial payment of rent. And in those kind of cases, if they have the clause that's required by the statutory section I mentioned, and again it is in the materials, then they're allowed to proceed with a detainer warrant without giving any kind of written notice beforehand to terminate the lease. And in that case, just like Jim had mentioned, they could proceed directly to detainer warrant regardless. Barring that situation and barring provision, and frequently that's a great way to help our clients cure their situation and avoid it. If they don't have that kind of clause, and they frequently don't, I mean, let's face it, boilerplate leases will. But don't forget, I'd mentioned earlier that oftentimes the boilerplate lease may not have provisions that comply strictly with the notice that is required under the statute. I can't remember the statutory section off the top of my head, but again, that is in the materials. I just saw it. It's 6628505, and it actually says it has to be at least 12-point font, and it's got to be in bold. 66, sure, 6628505. And that section's entitled Tenant Noncompliance and Termination. And it's an important part which allows for the cure section, and it also talks about that you can waive your right to notice for non-payment of rent, but it does specify what kind of fine has to be provided and that sort of thing. Now, the other thing that's very important about any kind of acceptance of rent, too, is that if you accept rent without reservation, you then cannot proceed to terminate the lease based on whatever it is. Oh, I'm sorry. Is there another question?
Yeah, I'm sorry. I just had a question about so if the tenant can waive through the lease, can waive the right to notice, are there other rights in the Landlord-Tenant Act that can be waived or cannot be waived within a lease? Like if you see the lease
Right.
purports to waive certain rights in the act,
Right.
are there limitations on that?
Right. Actually, under the Landlord-Tenant Act, it's specifically prohibited. I didn't talk about that at first, but under 6628-201, waiver of notice, which includes what we were talking about, it specifically says that a tenant cannot waive their rights. So that's one that's carved out of, in general. So you can't do that. You can't do any kind of admissions or forego any sort of rights, at least under the statute. Now, that's probably something else that's commonly done, and that's probably something else that they put into rules. I talked about a little bit earlier about rules that they try to make for what you can do on your property or what you can have. So there's probably some things there that could even merge with some issues of rights. Did you forego a right, and now are they trying to terminate you based on something they didn't really have a right to do in the first place? I said right way too many times, that'll get confusing, but I think you understand generally. But no, you can't is the short answer to that. Now, what I was talking about too, though, that's really important and an important thing that we use is that let's say that the landlord claims that you're not paying rent or that there's some other reason that we're going to evict you, and they send a notice that says you either hadn't paid your rent or you're making too much noise and we want you out. Then if the person goes in and pays their rent and the landlord accepts it without putting on the receipt with reservation, then they've waived their right to terminate. Okay, and I hope that's clear. So, and I think that's an important thing to remember because that happens a lot, that they always fail to give them a receipt that says that I'm accepting rent with reservation. The idea being is that a landlord can preserve their right to terminate a lease that has been violated as long as they put that on any sort of rent receipt, so they can continue to collect the rent. A lot of landlords will either choose not to take any rent or, like I said, frequently they'll take it without reservation of rights. And that's an important protection for our clients, especially when you start talking about Section 8 and public housing cases. That can get confusing because, of course, the public housing may not be getting any rent or maybe getting a small amount of rent. But in Section 8 in particular, it's complicated because the government will be paying or some agency will be paying a portion of the rent and they'll be accepting that rent. So sometimes I don't think there's any case law directly on point in Tennessee, but we've made the argument that they're continuing to accept rent anyway, which typically has been pretty successful, at least in a general sessions court arena. But that's an important thing for our clients and a good protection for them, that if they continue to pay rent, then the landlord waives their right to that. And in a minute, I'll talk about some case law that actually supports that and would also be applicable in common law cases as well, or common law counties. Now, the case that I mentioned that is really important for our clients and applicable to both common law and to Uralta counties is the Morrison v. Smith case. And again, it's in the materials as well. The notice period must expire prior to the detainer warrant being filed. Now, what that essentially means is that let's say that let's use Jim's example where he said that the person didn't pay rent or they didn't pay rent for the first 5 days, and on the 6th day, if you had the waiver notice, then you could go ahead and proceed with your detainer warrant. Well, let's say they don't pay the rent and the landlord says, well, I'm going to send a notice of termination and I'm going to give you 14 days to get out. What has gotten confusing is it used to be that you had to give 30 days, and what the Morrison v. Smith case said is if you give it in the middle of the month, that means the 30 days goes all the way to the next full amount. So you would actually go roughly 45 days out before you could actually proceed with your detainer warrant. Now with the 14-day notice, it's a little somewhat confusing in that, let's say it's the 6th day and they give a notice of termination for 14 days. I would guess that means that you got to wait to the 30 days. I don't think that there's any sort of law or there's been any case law directly on point. But the most important thing to realize with Morrison v. Smith is that you definitely have the right for that period of time to expire before the landlord has the right to file the detainer warrant to actually take legal action to get them out. So if it's, for instance, Jim said the 6 days, then on the 20th day or the 21st day is when the landlord would actually have the right to file the detainer warrant. You'd be surprised at how often they don't do that. They don't wait until the time period goes. And that has been a successful way to get the detainer warrant dismissed and utilized the Morrison v. Smith case. Again, it's in the materials. I don't have the site right here in front of me, but it's definitely in all of your materials. So that's a really good case that actually David Kozlowski out of Columbia was involved in quite a few years ago. Did I explain that clearly? I want to be sure that, because that's really been something that's successful for us in keeping a client in their property.
Again, that's only in the 16 or 17 counties that have 68,000 or more people that are under the URLTA. Right?
No, that's not limited to Uralta.
Okay.
This case was actually a Court of Appeals case that was basically just general landlord-tenant law, which I think would still be applicable, of course, to Uralta. I don't think there's any statutory provisions that would override that in those counties.
Okay, so that's good in all 95 counties.
In all 95 counties, you shouldn't be able to file your detainer warrant until the time that they gave you notice of termination has elapsed. And in Uralta, that's 14 days. I didn't have the common law statute. If you're in a common law statute county, you'll want to check that statute. I think it's very similar now. I didn't include that in the materials, but it also has somewhat of a same provision. But the most important thing is the amount of time that the landlord said for you to get out has to elapse before they have a right to take legal action. And one of the ways to sort of understand that is that what the Morrison case basically said was, well, you're not detaining it unlawfully until you've exceeded the time that they've given you to be there. And so theoretically, they used to call it an unlawful detainer warrant or action, and sometimes they still do. And so until they're holding the property beyond the time you have permission, then, of course, you really doesn't have a right to a detainer warrant anyway, or detainer action.
Would you speak about the difference between filing the detainer warrant and getting into court to have it heard?
I'm sorry, she coughed about the time you said that, and getting it to be heard?
In court. And
Filing it and getting heard?
Yeah.
I mean, that's going to depend on every county. Every county is a little different. Most of our judges treat detainer actions and possession of the property much more serious, frankly, because I think they're also property owners and know the headache of being a landlord, so that they'll try to get those set fairly quickly. If you file the detainer warrant, and they get served, usually you'll have, I would say, a couple of weeks before you at least are before the court for a docket call. And that's going to vary widely, so that, that's not going to necessarily be applicable in smaller counties. They may do it quicker. But, from the time they file the detainer warrant, they then get them served. I think there's roughly, in Montgomery County at least, about a 3-week period before you have your first day in court. Now, that goes back to, and again, apologize for repeating myself, but that goes back to why it's so important for landlords probably to include that provision that waives right to notice, because then you don't have the notice of termination. You got to wait that period of time. Then once the notice of termination period has expired, then you file your detainer warrant. So you're effectively adding another 3, probably even close to a month before you've even filed your civil action to get in court. Then if you add what you're referring to, the amount of time before you're actually in front of a judge, a landlord would be in a position of probably not getting rent or getting satisfaction for maybe as much as 2 months, sometimes 3 months, as she just indicated to me very forcefully. And so sometimes that's very aggravating for them. And if they're not being paid, I somewhat understand. But it's something important to point out about the Landlord-Tenant Act. What it's intended to do is make some equitable and some sort of procedure recognized for both parties. So while it can be sort of a headache, at least perceived by landlords, it's simply saying we've got a set of procedures you need to follow. And like I've been repeating over and over, all a landlord really has to do is include a provision that says I'm going to waive your right to notice if you don't pay me rent, because I shouldn't have to wait because you didn't pay rent. That's sort of, I think, the logic behind it, that I don't really have to notify you that you failed under your tenant agreement if you don't pay me rent. You fully know when that happens. All other things, you've got to give them some sort of notice and let them know what it is as to why they're terminating the lease. I'll repeat again, though, that it's probably 90%, if not more, is non-payment of rent as to why they're in court or trying to get the tenant out. So I think, did everybody sort of understand what Morrison v. Smith stood for and the idea that you have to wait that time, and that's really an important part of defending actions in General Sessions Court for tenants. There's also another case that I mentioned earlier, how important it is that one of the great defenses we've used, or one of the things that you can use to keep your client in, is acceptance of rent without reservation. And there's a case, Woods v. Forest Hill Cemetery, that also stands for that principle as well. Again, I included that case in my materials. And it's kind of an older case, but I think still applicable, and has a very clear statement. And I was just in court with this case in Robertson County about a month ago, utilizing this case, that acceptance of rent after you've notified them of termination means that they're waiving their right to terminate. And it's some very clear language in there, and I don't think there's been anything that has overturned that, certainly. But that's a real clear situation. The other thing, it gives you a lot of advantage, because if your client's trying to pay, then obviously the judge is more reluctant to want to terminate as well. But the Woods v. Forest Hill Cemetery case stands for that same principle that is in your ROLTA, which says acceptance of rent is waiver of your right to terminate. That's pretty much what I had on landlord-tenant law. Like I said, I included all those statutory provisions, or certainly portions of them, in all my materials. I think that if during the volunteer lawyer project, or if you took a case pro bono and you were looking at landlord-tenant, I should have stressed, and I meant to mention on the front end, that you're welcome to call me. My name and information is included in my materials and in the general thing. Again, my name's Kevin Fowler, and I'm at the Legal Aid in Clarksville, Tennessee. The number there is 931-552-6656. But like I said, all the materials have my information on it too. And if you're defending someone like that, most of the time it is based on non-payment of rent. And so a lot of times, if anything, you're sort of just buying time and expecting the landlord to abide by what the rules are, and not providing proper notice, accepting rent without reservation. All those sort of things can really benefit you in trying to preserve your client's time. And sometimes it's just a matter of negotiating at that point. You try to use the statute, your ROLTA, as leverage to help your client. And then sometimes it's just a matter of they want to move anyway, or they want to provide find alternative housing. And then sometimes, though, however, you are in a position to actually defeat any kind of detainer warrant and maybe get a long-term resolution. The problem with all these cases, though, is usually you've already got a bad relationship between a landlord and a tenant, so perpetuating that's not really going to help anybody. So sometimes the more practical solution of finding alternative housing is okay. But, usually you're representing families, and so you're talking about children, and you're talking about people who can't afford to move, and where do they go? And so by the time you've added up all those kind of problems, it's really important that you can use your ROLTA or Morrison v. Smith or the Wood Hills case as some kind of leverage to at least preserve your client's housing for that amount of time, and at least give them some degree of stability. And fortunately, or unfortunately for some landlords, they're oftentimes not following these rules. So a lot of you lawyers out there, if you're going to do volunteer lawyer work for tenants, if you can get to the landlords, maybe it'll be a little lucrative to kind of come up with just some guidelines. And that's what I used these statutes for in Montgomery County, by the way, is that I talked to the Bar Association and just said, look, these are ways you can get your clients to just follow the rules. It's not always that we're trying to keep a client in there when they haven't paid their rent. It's more that we're just expecting them to follow the rules just like they expect the tenants. I don't mean to sound preachy about it.
I'm going to throw in
Jim.
one more quick comment. You are too modest. The Legal Aid Society has incredible self-help tenant booklets that are just rock tight for both URLTA counties and non-URLTA common law counties, and they're at the website at las.org.
Right.
And even though they don't have the citations for lawyers, they are fully consistent with the law, and a lawyer can read them and know that they are backed by the law. Yeah. So you go to the self-help booklets at las.org and click on housing, and you'll get a wealth of information as a pro bono attorney.
Right. So in addition to calling me, check that out too. And it hadn't been, there are occasions where we have to practice law by pamphlet in our office too on occasion. But let's go look at the pamphlet and see what it says about Medicare. That happens quite often. And landlord-tenant can get a little complicated, as you can imagine, in the notice requirements. I hope I kind of touched on what it is. Does anybody have more of a question about just generally what to expect or anything like that about a landlord-tenant case in general sessions?
You said something about debt collection.
Mm-hmm.
Did you cover that, or
No, I haven't covered that. That's the next section. So I'm about to tell you about that because I do a whole lot of debt collection. So I just wanted to be sure if there were any questions about landlord-tenant, or if I at least provided some light on the subject and what you might expect if you do pro bono work in that area. Or if you're helping, apparently I was also trying to help some of the landlord bar as well, which I'm sure I don't have to, but if hopefully that'll help again, just make uniformity across the board and people know what to expect and they just follow the rules and you don't have to worry about it. Okay? And I should say landlord-tenant is one that I do some work in. We have another person in our office that is doing a lot more, and I do less of that. But an area that I do a whole lot of work in is debt collection. Has many folks here done defensive work in debt collection actions in general sessions? Okay, good. Since there's not anybody, I might sound like I know what I'm talking about. What happens in debt collection, this is our typical client. What we try to prioritize, or the ones I do, are frankly usually elderly clients that have a credit card debt of some sort that they haven't seen or had any interaction with for usually at least close to 6 years, because that's the statute of limitations. And suddenly they'll get a civil warrant served on them from several different debt-buying organizations do this. And there's a large creditor bar that, of course, does these kind of lawsuits, where that company has purchased the account from Citibank or Bank of America or, whoever had the credit card originally, and now they're pursuing them for payment for a debt that at the time she probably quit, or he quit performing on it, was maybe around $1,500 or $2,000. But by the time they've added all the interest and all the penalties and everything else, it's suddenly $5,000 or something exorbitant. And it really caused an amazing amount of stress and concern, especially for the elderly clients that we represent. I keep stressing the elderly clients because I'm going to talk about some self-help ways that a client can protect their assets and income and other things. And let's face it, the more sophisticated or younger that a client is, the more likely they're able to kind of navigate that in a general sessions case, and I'll talk about that. But in our case, I'm more concerned with elderly clients that are experiencing that kind of harassment or that concern. And, it can range from them worrying about going to jail because of that. Am I going to lose my house? I don't have anything. They'll take Social Security. Most of our clients typically are going to be making an income of less than $1,000 at best. And so for them to take any portion of that money and try to pay an old debt that frankly was purchased by a company for probably pennies on the dollar is something that I don't mind trying to help them avoid. And it's that special case that we have a lot of those. And if you go to a docket call in General Sessions Court, for instance, in Montgomery County, you're going to see a packed courtroom, and I would say at least 80% of them are those kind of lawsuits. Maybe 70. I'm just, ballparking the amount. The point is, it's a huge growth industry. It's kind of settled out lately, and I've heard there's been a lot of changes in the creditors bar recently, so I don't know what's going on. But, when I started practicing, you'd never see that. You'd see mostly some landlord-tenant action cases and things like that. But now it's a big part of our general sessions practice. Just checking the time. Of our general sessions practice is defense of debt collection. And the great thing about those cases is that they're not terribly complicated. There could be some more complicated issues involved, like Truth in Lending Act problems, improper debt collection practices. I'm not really going to go into that, because if you're going to do that, you're going to want to commit yourself to probably a broader practice in that area. But the important thing is that you can help people who say, well, yeah, I owe it. I remember having a bank account. I don't remember it being that large. That's typically what they'll tell you. And on occasion, they don't even remember having it. So the question is, how do I handle a case like that? What can I really do to help them? How can I assure that they do what's proper? Or if they're in a position where they simply can't afford to pay anything, that I can protect their assets or income so they just don't have to worry about it. And that's why I would stress, I know young people need not to be stressed too, but, the elderly clients are particularly appealing because of how much that affects their health, how much that affects their general quality of life. And you just wouldn't believe how thankful they are about that kind of help. And so I'd really urge, if this is one of the things or one of the reasons you are having this session, that you consider doing those types of cases. And I'll go through and explain some of the things about how to represent them. I just realized I skipped over one section too real quickly that I should talk about, is debt collection of old hospital debt too is also a big issue. And I included in my materials, and I don't know if anybody's ever seen this case, Doe versus HCA, which was a Tennessee Supreme Court case. And I only raise it that if you are representing people, and since we don't have health care coverage in Tennessee, this is still a pretty big area problem. I should have said, in addition to credit card cases, I represent a lot of clients in hospital debt. Doe versus HCA is an important case out of the Tennessee Supreme Court, where they said you cannot reduce it to a sworn account. You can't say that the debt that the hospital has against the individual that usually accessed emergency care or something like that is reduced to an amount that is identifiable, because it's not for breach of contract, because the arrangement was not sufficiently unambiguous to constitute a contract. So the terms are too ambiguous. So what they said is any kind of recovery in a hospital case has to be by quantum merit or unjust enrichment. So they've got to come in and prove what is the reasonable cost of what we're trying to charge them with. And if anyone's familiar with low-income clients or people who've gotten hospital, well, anybody, I'm sure y'all have seen hospital bills. And, I can remember where they were charging somebody $1 for a vitamin C pill every day. So the question then would be, well, is that a reasonable cost? And so it really could get very interesting. And they've even tried, there's lots of cases out of Chicago, and there's been a real big movement to try to get, well, what are the insurance companies paying? And we all get those statements, and it's very complicated as to the difference between what they claim it would have cost us versus what Blue Cross or whoever paid. But the point is, in these cases, and I'm getting too confusing, the point is in these cases is that the hospital really has to prove what the reasonable cost of what they provided the individual was. And in the example I gave you, they shouldn't be able to prove that it should be $1 for a vitamin C pill. And, most of these cases, if you have a client who's judgment proof, and I'll explain that later, I'm sure most of you all understand that, but I'll talk about that in a minute. Most of the time, you're probably negotiating a judgment amount anyway. But certainly, if you get somebody that's particularly aggressive, and it seems a particularly egregious debt that they've tried to claim they owe for whatever health care they perceive that they received, then utilizing Doe v. HCA to force them to come in and provide better proof than simply a sworn account or some sort of person from the billing department who simply gets up there and says, we have an account with this person, they owe us this amount, which would have been traditionally what the creditors bar was hoping to continue. But the Tennessee Supreme Court said in Doe v. HCA, you got to come in and prove what the reasonable cost of that is, just like any other contract or quasi-contract situation where you don't have a clearly identifiable contract that you can measure the damages. So I did want to mention that real quickly because I did have that in the materials. I included that case in my materials as well, and it's a really interesting case. And it'll remind you of all the things that you quit remembering about quasi-contract when you were in law school, or at least I did. So was that clear about that? Did anybody have questions about hospital debt cases or anything? Mm-hmm.
How are they typically proving it?
I don't know typically because I haven't had a case where we've really pushed it that far in a while. I do know that they referred in the Doe case with you could use hospital bills and cost and payments from other regions that are similarly situated was one model. I think that case came up with a couple different ways that they're allowing the hospitals to try to prove what is the reasonable cost. Because let's face it, what the argument is on the side of the hospitals is, well, an emergency room vitamin C pill is going to be different than if you just have a stay in the hospital. Because what happened was when they fought these cases, they were coming in and saying, well, hold it, Blue Cross Blue Shield only paid you 20 cents for this vitamin C pill. Why? And I'm just giving you all rough examples. Why is it you claim that Miss Johnson, who, appeared in the emergency room with chest pains, is being charged $1 for this same thing? So that's where you come up with the thing of, well, what's reasonable? So I think at some point to try to give practical help, and there's probably been some developments in that area since the Doe case because it's been out a while. I think what they've allowed is for you to use similarly situated hospitals and what is their cost structure and what do they charge, and sometimes that's sufficient. But as you can imagine, that's still pretty arduous. I mean, you'd still have to be bringing some sort of expert or somebody in that can testify. And let's face it again, don't forget, in General Sessions Court, you've got such a wide array of judges and how they would look at cases. I will say debt collection is one of the areas, and I'm not talking bad about General Sessions judges at all, but it is one of the areas that the judges tend to be more skeptical of plaintiffs. You know, I think they don't like it, and they see a lot of little old ladies coming in, and in hospital bills as well. They look at that, and they do hold them to a standard, a sufficient standard to try to come in and prove it. So they'll push them a little harder on that and won't accept. But let's face it, you could probably get somebody in there that was simply qualified as an expert, and they just say, is that a reasonable amount? And a judge may accept that as well. But I think, like I said, if you look at that Doe case, I think the Supreme Court even went in to a couple of different models. For some reason, I'm thinking Missouri model or something. I can't remember for sure. But there's a couple of different ways that they've allowed them to prove it. And don't forget, that's General Sessions. Now, if you're in General Sessions, and I didn't really mean to get into this, but it's important to remember the great thing about General Sessions is you can't make a mistake in anything involving damages that you can't cure with an appeal. And if you do an appeal, you're upstairs in circuit court and you got a brand new case with no court record and you're starting all over. So sometimes you even use that, of course, as discovery to figure out what they do have and what they don't have. And if you get up there, you're even opening yourself up for countersuits and things that you may be able to go against them with. And I should say real quickly, gosh, I didn't think about this, but if you're in General Sessions Court and you're wanting to appeal something and you're thinking, oh, what about bond, because that's a very complicated area of the law, you can waive that with an affidavit of indigency. And I guess the bottom line is you may just want to call me if you have something like that, because I'd be glad to email you any of that. And I didn't include that in my materials, but I'd be glad to provide that because it's such a simple thing, and that's a great way to be able to access courts of record and get out of General Sessions Court, because that bond issues and paying the filing fee has become a real bear for a lot of our clients in trying to get up to the next level. And I should say las.org may also have some of that information as well, the website that he mentioned with pamphlets.
Kevin?
Mm-hmm.
Over here.
Hi, Kevin.
Hi.
Hi. On the issue of insurance payments, because we've had an onset of government requirements indicating everybody should have insurance coverage, if we have a client who is not paying their hospital bills, what are your thoughts about the low end, high end, and coming up with a middle range? Low end being Medicare, Medicaid for payments for services and pharmaceuticals, versus high end, let's say Aetna Insurance, and then a midline could be Blue Cross Blue Shield, where they have different policies that meet the requirements for payments for everyone. That's number one. Number two, how are you looking at, when we go to court, how do we look at the deductibles? Because that's an issue, too, for clients who are not paying their bills, because the insurance companies are not paying, and also the copay. How do we address those issues?
Well, the first one with regard to the difference in how you measure the amount of I guess you mean in the sense of if you were trying to negotiate a settlement with them and what could they agree to allow between those varying differences in cost of, because otherwise I don't think, I think typically what a hospital would say is, look, this is our billing and this is what we charge, and if there isn't covered insurance or if this isn't stuff that wasn't covered, then they're going to have a different cost structure and a different amount that they're just going to charge them. I don't know if that's negotiable. Now, whether they'll negotiate down the amount that they claim just simply because they know that it may be an uncollectible debt or something like that, I could see that happening.
I'm thinking about strategies, even if you're in the settlement component, but outside of settlement. Let's say the institution does not desire settlement, and you have to go and proceed with your case. If I'm if I am the defendant's attorney,
sure,
and I want to justify a lower payment, would it be reasonable to include in the evidence, or with my forensic parties, evidence identifying what the insurance company paid to show how much more the hospital paid, required for payment?
No, I think that'd be great, and I think what you were talking about is Medicare, the cost structure that they would pay or what they would pay for hospitalization or whatever, and why couldn't you use that as proof of what should have been charged for this individual? I think those are all great ideas. The biggest problem would probably be is that the hospitals would say, but they weren't Medicare. So the cost structure and what we had to pay and what it cost us to maintain a hospital based on people and the amount of money we get, our costs are so much higher, we have to charge them more. At least that would be the response. But I think it'd be a great idea to utilize like Medicare payments or what would be the normal Medicare payment or what does Blue Cross pay in this situation. That's why I mentioned the 20-cent vitamin C versus the $1 that they billed them for because they weren't covered at all. So I think it'd be a great idea, and I think that's what you meant.
Well, ICD codes, ICD-9s will soon turn to ICD-10s, and procedural codes have amounts assessed to them. And that's kind of more than what I think this population needs. Right. But because there are assessed amounts, there is a way to quantify what a reasonable payment is.
Should be, sure.
Yeah, well, there is. Now, especially since everybody's now required to have insurance.
Mm-hmm.
So then you and I'll talk later. But
Sure.
anyway,
and as you can see by the look on my face, she's exceeded anything I know. So I don't know, and so I may call her as an expert. I mean, she'd be good to bring up there. You know how that is. Any expert you can throw at the judge, the better off you are because they don't think you know anything. So if you can get someone who can go into those kind of cost structures, and I vaguely understand what you're talking about, and now that you do have to have insurance, that is changing a lot of the cost structure, and the fact that I assume, and I really don't know this because I hadn't experienced it, but the Affordable Care Act has all sorts of requirements as to what they charge. And matter of fact, I almost forgot the most important thing. Gosh, and I learned this in the Tennessean, so don't laugh at me. But supposedly under ACA, the hospitals can't charge more than what they pay insurance anymore if they accept certain funds. Now, that's why I mentioned the Tennessean. That shows the depth of me knowing that. But the point is, it's an spot issue. If you're in a situation where you've got a hospital bill and you've got that, you also now have to funnel in the ACA. And yes, VHCA is well before the ACA was passed. So, and since we opted out at least of the Medicaid, sometimes you forget that, but apparently there's even an imposition of that. So the short of it is, you get a hospital bill case, you're going to want to look at VHCA, you're going to want to look at ACA and any other provisions that may be able to control the amount that they charge your client. And what she mentioned is, I'm sure in a more sophisticated way than I can comprehend right now, is that there's all sorts of ways to try to determine what would be in a reasonable amount to charge this person for these procedures. And what you're probably going to be dealing with, in most of our cases, our clients are judgment proof anyway, so you have a lot of leverage from that. But what you're going to be dealing with is that you're going to have a hospital that's going to supposedly come there with an expert that can counteract that and say this is what we would charge. But I think the ACA part, and gosh, thank goodness I thought of that in the middle of this, the ACA and the Affordable Care Act and the imposition of what you can charge somebody may be a great way of controlling the amount that they're trying to charge the client. And thanks for bringing that up, because otherwise I wouldn't have thought of that. So think of all those things. Now that was something that I thought I almost overlooked. So what I really wanted to talk to you about also, and did that kind of cover what you were talking about? Okay, yeah, and thanks for bringing that up, really. And the next thing I wanted to talk about is just straight debt collection cases. Let's go back to the scenario I talked about where a client gets a civil warrant. They either do remember this credit card or they don't. They definitely don't know who it is that's suing them now, because that's going to be a company that simply bought, millions of these accounts. And by the way that works is they buy those accounts, they even equitize those and put them on Wall Street and sell them much like they did mortgages. So that's a big industry that's out there, although I think it's changing a lot. So, but then they come after people who have these long dormant accounts. Of course, the first question is always statute of limitations. So you may have an argument to be made that it's well past the statute of limitations. Typically, that's measured by when were they last substantially performing under the account. That's always kind of an ambiguous thing, so you may be able to get by with filing a motion to dismiss to simply get it dismissed because it's beyond the statute of limitations. But other than that, the next question is, and most of the time I haven't had that. Most of the time they're well within the statute of limitations or just inside of it. So what can you do? How can you defend the client? What is their situation? In most of our cases, I've been mentioning judgment proof, and I think everybody understands what that is. But generally, you can ask a client about 3 questions. What is the nature of your income? Do you own more than $10,000 worth of personal property? And do you own a home? And in Tennessee, that there's so many ways that all those things can be protected, or they already are protected, that most of the time, and I even call it comfort law for my elderly clients, you're just assuring them they can't do a thing to you. You may not even have to go to court. And you just don't know the relief that they feel over the idea of not going to court, because most of these folks have never been to court, and it's terrifying for them. So the important thing to remember, you just start off with those 3 real basic questions. What is the nature of your income? Do you own more than $10,000 worth of property? And I'll explain why all those are important, and I'm sure most of you know, but why those are important. And then, do you own your home? The only time it gets a little complicated is if they own their own home, and I will discuss that in a minute. So, and frequently the client will say, well, I don't even remember if this is my debt, and most of these debts are filed on what's called a sworn account. And I've got all this attached. I should tell you that most of these things I'm referring to, I've got the sworn account, and I'm about to talk about exemptions. All of that are in my materials as well. And they're at the AOC website, and that connection if you don't have them. But the first thing that happens is usually they do a sworn account. I mentioned that in the hospital debt where they said it's too ambiguous. Well, in a sworn account, basically you've got a contract, so they're basically reducing the amount that they say is owed to a specific amount, and then they have someone swear off that this is an account this person owns, and they owe us this much. And technically, you're supposed to do a sworn denial in order to avoid that being an automatic amount that's correct. Now, under the statute, it actually allows that individual to just declare that in front of the judge. It used to not be that way, I don't believe. Used to, you had to do a sworn denial prior to court. A sworn denial is quite simple, too. I do not believe I owe the debt. I mean, it's nothing too complicated. And so that just forces the plaintiff to have to come in and prove it at that point. Now, the way we handle those cases, usually, one, you could do the sworn denial, which is okay. I think you can still handle it anyway without doing that, but that's probably the best practice to go ahead and file it. And then usually you appear at the docket call, and what I do with the plaintiff's attorney is we'll provide us documentation. It's the first thing you do. One thing it does, it buys you a lot of time because they usually don't have the documentation available at that time, and usually it's going to take them a while. And then, fortunately, you can actually look really good because a lot of times they'll discover their client really doesn't have it readily available, and they'll end up non-suiting. So you actually get a dismissal in a very simply by showing up and showing that you've got a client that you're going to represent and at least force them to come up with proof of whatever debt is owed. So that's the first thing that happens. The next thing may happen is that they then provide you with proof. I think there's a range, and just a practical range is if a client tells me, yes, I do owe it, then, sometimes their statements, lawyers handle this differently. Some lawyers will say, look, I'm just going to force them to do it, and I'm going to trial, and we're going to fight over this. I think you have to measure that practically against your client, whether your client really has the wherewithal or the interest in really fighting over it. So you can push them if you want to see what they have. But eventually, a large percentage of my clients are just happy to know they don't have to worry about it, which I'm about to tell you why. And so sometimes they may agree to an amount being entered as a judgment against them if they truly think they owe it, and if we can get it down to an amount that we think is consistent with what they think they might owe at that point. That's pretty hard to tell given the amount of time and the amount of interest that's probably accrued. And don't forget attorney's fees are tacked on at the end of that as well. So it gets pretty expensive. And I got to get my train of thought. I was just told I had 10 minutes, so I'm having to get back on the train. And so what you do is you tell them, provide us documentation. You go over it with the client. And if the client is satisfied that that's their debt and that's the amount. Now, usually I'll even talk about contract, but don't forget in a credit card, your use of the credit card upon receipt under the federal law is actually assent. And so you've contracted at that point. So frequently you're not going to have, almost all the time now, you're not going to have some slip of paper with their signature on it or anything like that. But But again, I want to stress that that's the minority of cases. The vast majority of cases, the client says, sure, I remember having a Citibank card a long time ago. I just forgot about it and couldn't pay it because of, I lost my husband, or just there's usually some sort of income change that resulted in that. So the question then is what can I do to protect them? What does the law allow me to do? So let's say a judgment is entered either because you did go forward with a trial, or they agreed that, okay, you've sued her for $8,000, but we're going to agree to, say, a $4,000 judgment, and then they're wanting to know about payment plan. And the wonderful thing is usually you can say, well, my client's on a fixed and limited income, which is the form letter I usually use, and they are not able to make appreciable payments. And if their income is Social Security, SSI, or a number of pensions, then none of that can be touched by garnishment, nor can it be taken out of their bank account once it's deposited. I'm going to tell you more ways to protect it, but that's a big percentage of the cases we would be involved with. People who either have SSI, which is supplemental security income, or Social Security income, and sometimes a small pension. None of those under state law can be attached, nor can they be garnished in satisfaction of a judgment. So that's the first thing to understand. Then in addition to that, you can protect, even beyond that income, you can protect up to $10,000 worth of personal property. And again, I have those statutory sections. So frequently our clients don't even have cars, but the only thing that the bank or that the creditors bar is looking for usually is, can I get to their bank account, or can I, and they really don't even go after automobiles, but that's the biggest thing to protect. You don't have to worry about other stuff. Typically they're not going to try to go after anything, or they haven't since I've been practicing. But bank accounts is probably the biggest thing. So in the state of Tennessee, I've said before that you can protect up to $10,000 worth of personal property. So if your client gets a judgment, or if somebody shows up and says, I had a judgment against me a long time ago and I'm worried about them coming after my bank account, or they just tell you that and you think, well, you better protect your bank account, because what will happen to them is suddenly there's an attachment. It may even be only Social Security money, which they can get back, but the problem is once they've attached that money, as you can imagine, then there's bad checks, and then things just roll out of control, and it gets worse for your client. So with a very simple form, which again is included in my materials, you can do something called a debtor's claim of exempt property. And you simply list the bank account, and you can do one of two things. If all that goes in that bank account is Social Security or SSI or pension, then you list it in a certain section, and it's protected, period. And it doesn't even count against the $10,000. If you want to list it for an amount, because sometimes they get cash from other sources, sometimes family members give them money, things like that, then you can list it for whatever amount you know it won't exceed. So, for example, somebody who doesn't really have much of anything, doesn't have a car, you could list their account for $5,000, and as long as they keep $5,000 under there, and you file that with the court, of course, and send a copy to the plaintiff's attorney, even with a judgment, they can't touch that account. And that's a quite simple thing to do that has an amazing amount of return for that client, an amazing amount of security that they'll feel, not having to worry about the fact that they may go after my income. They obviously, I've already said, can't garnish Social Security or SSI under those circumstances, so that's already off the board as far as trying to go after their income in that way. The only other thing is you want to be sure and protect their bank account. And then in addition to that, at least frequently our clients at best have a car worth a couple of $1,000s. That's even rare, but you list the car too, and it's like having extra insurance. Like I said, I haven't seen any creditor try to attach a a car in a long time, but they'll definitely go after bank accounts. So that's a great thing, again, back to the comfort law, making sure that individual knows that their income's protected, their bank account's protected, and if you need to list some property, you can. And sometimes my clients want to list property even though I know it's not going to be attached. And again, that goes back to comfort law. They feel better, and you've listed it, so they know that they can't go after that property. There's certain other specific listed ones like Family Bible and things like that that are already automatically protected under the law and are exempt from any kind of attachment. But those are the things you can do. And again, bank account, bank account, bank account. You just want to list it for something so you know your client doesn't have to worry about it. The next thing is, of course, if they own a home. They can always file a judgment lien against the home, so that's always a primary concern when you think they may owe it and you're trying to resolve the case. And the exemptions are all, again, I've provided the statute, but I will tell you real quickly what they generally are, because they actually have been changed over the last, few years. And but what they can do is you get a judgment. All you have to do is file judgment lien against any real property owned in that county. They file it with the Register's Deeds Office, and then their judgment is secured by the real property that person owns. And, of course, everybody understands that if there's a principal mortgage or principal against it, obviously that takes precedence. But they'll have that judgment there, and if you have post-judgment interest, it's roughly running about 5% now. So that's going to keep going up. So that is the other negative about it. But I haven't had a case, and David Tarpley, who's done way more consumer cases over all these years, says he can't recall the last time that there's ever been a creditor try to actually force a sale. Just because you get a judgment lien against the property, you then would have to take action in Chancery Court to force the sale of that property to satisfy that judgment. I haven't seen that done. David said he had, and I hadn't had anybody tell me they've seen that done recently, especially in the cases I'm describing. So that would be an unusual step, although it is a potential, so it's always something you have to consider, but we've never seen that happen. Otherwise, the judgment lien simply stays there, and until that person either passes away or passes the property, then that's not satisfied until that's done. That still provides the clients usually with a great degree of satisfaction and happiness that at least they're secure in their home, because that's the only thing they're really worried about. Will I lose my home, and are they going to take my income or my bank account? So real quickly, because I think I was down to about my last time, although I can take a few more questions if there are any. With the real property, it's very specific. An individual can claim, if they're under 62, can claim up to $5,000 in equity. A couple can claim $7,500. And I only mention this because it gets kind of interesting that above 62, it's $12,500. And then if you're a couple and one of you is over 62 living in the home, you can claim $20,000. And then it's $25,000 if both of you are over 62. I just think it's curious, and I wonder where they determined all these numbers from. And then finally, and most important for our clients, and something that hasn't come up much, but if you're a single parent with a child and you have custody of them, you actually can claim $25,000 in equity in your home and protect whatever $25,000 you have against any kind of attempts to collect that through a judgment or anything like that. Okay, and don't forget, that's only if your property is being sold or if they're trying to do that. And you can assert that exemption at any time. With regard to the personal property exemption I was talking about, you definitely want to get that filed after the judgment is entered. Don't forget, no judgment is final for 10 days, so really nothing can happen, and it's rare for it to happen that quickly. But you definitely have that amount of time before you actually would have to file your exemption. Keep a copy, send a copy to the lawyer, make sure your client has a copy. I recommend sometimes they give it to the bank. It's just an extra precaution. And if all else fails, appeal it. You got 10 days to appeal it, and call me if you want an affidavit of indigency or anything else you need so that you don't have to worry about a filing fee. And I think I hit right on. Oh, I got a question.
Kevin, as you've indicated, there's an awful lot of creditor abuse out there. I mean, an awful lot of it. And let me plant a seed with some of you folks that, I mean, I know all of you are here, on behalf of Access to Justice. But one of the things that we do in our county is we go to General Sessions Court once a month, and we find out when they have the biggest creditor docket that there is. And we go in and we represent everybody. We just go in and just say, we're going to volunteer, we're going to represent everybody here. We'll try 30 creditor cases or debtor cases. And, it's worked out real well, because actually it was the General Sessions judges that reached out to us and said, you all are doing all this other access to justice stuff, but the rubber meets the road in General Sessions Court. So, I know that doesn't always work well. It may not work well for Davidson County. It may not work well for a lot of other counties. But it's an idea. Let me plant that seed. And even if you can't do some program like that, a lot of times if you're sitting around in a courtroom and you're seeing somebody's ox getting gored, you can reach out to them and grab them in the hallway and say, let me tell you a couple of things about access to justice, or about what we can do. Right. One of the things we do actually in defense of the cases, anytime a debt is sold to a third party, we're probably 99% successful in defending all of those cases. So.
Right. And what county are you from?
Washington County, up in Johnson City. Yeah.
Okay. Yeah. And that's a great idea, and he describes exactly what happened. And frankly, I've been in court on other cases, and you'll just see, as he mentioned, he said the ox goring the client. You'll also see clients that are just more vulnerable. folks, and it's not just identified by their disability, but let's face it, people in wheelchairs, people with oxygen, people sitting there in a docket call, and you can tell they're just laboring to get through it. And sometimes you can find out they're there on just a useless credit card case. And so there's been times we've reached out and represented them as well. And, you know, I will admit that at Legal Aid there have been some discussions about how we could approach a more broader representation of these large numbers, because it really will be one lawyer there with a stack of warrants like this of 100 lawsuits, sometimes more than that, and just calling out names, most of the time taking default judgments. And if they don't, at least in Montgomery County, they take them out in the hall and they talk with them about it. Well, you know how people are. They're scared to death to go in front of a judge, so they, at all costs, don't want a trial. So what they'll end up doing is agreeing to a judgment, and they really won't even know that they've agreed to a judgment. Then suddenly their bank account's being taken. So there is a lot of abuse he's talking about. Most of the things I probably described are inappropriate even legally. So there is a whole lot of things in that area of the law that you can help people with, and it's people that you definitely, although everybody deserves representation, it's certainly not people that you would have trouble helping, because it is usually vulnerable populations, obviously low-income populations, and like I said, there's a large number of elderly clients that we have to help with those kind of things. And I will say real quickly, too, one reason that drives us to do those cases is because I mentioned the exemption and the property exemption, and if you go to las.org, and you're welcome to tell clients to do that as well, they have excellent pamphlets on how to protect your personal belongings, how to protect your bank account. So there's a lot of really great self-help information that very clearly explains how people can protect that. But that's why I bring it up, that I'm concerned with some of our older clients and less sophisticated clients that they really can't navigate that, and they're too confused to really understand what that is sometimes. But generally, it's excellent, and it's very understandable, and it's a good source for people who are just wage earners, who are just trying to avoid having a more difficult problem. And don't forget, there is something called a slow pay motion, I should say real quickly, and I didn't include that in my information, but if they get a garnishment, you can stop a garnishment by filing what's called a slow pay motion. Every county is a little different, but you could probably send, almost in every county, your client to the clerk's office and just describe it as a slow pay motion. I think on the AOC Access to Justice site, there's a lot of this information too. I should have mentioned that at the very front. And some of these things are there as well, but certainly ours. And I think SELegal.org has some amazing forms and information as well, along with the AOC and along with las.org.